I think we should start now. You were going to
Yeah.
start. I guess we've already started on discussing the oral argument logistics. Maybe you could give our attendees a little bit more background on that.
Yeah. Hi. So for everybody just joining us, I think we've just gone live. My name is Tejinder Singh. I'm an attorney, a partner at the law firm Goldstein and Russell, does Supreme Court litigation, and I contribute to the SCOTUS blog as well. I'm joined today by John Duffy. He's a professor at the University of Virginia Law School, and he knows a thing or two about the Supreme Court, having clerked there for Justice Scalia and practiced before the court a bit as well. We're really excited to be welcoming everyone who's joining us today to talk about these upcoming oral arguments. We're going to be previewing the first oral argument that's going to be conducted by teleconference, which is in the case of U.S. Patent and Trademark Office versus Booking.com. And this is a case that's about whether this particular trademark can be registered under the provisions that allow businesses to get protection for that kind of intellectual property. Before we dive in, though, this is kind of an interesting moment in the court's history. We have oral arguments happening by teleconference for the first time in remembered memory. And so the way this is going to work is going to be different than normal oral arguments. For those who have not been to a Supreme Court oral argument, it's normally quite a fascinating and free-flowing discussion between the justices and the advocates. The lectern is just a few feet away from the bench. The advocate stands there and gets grilled, usually by whoever has a question, just jumps in and asks it. Interruptions are quite frequent. It can get heated. It can get very interesting. But the system that the court is using for these arguments is going to be just a little bit different. They're using a teleconferencing system, and all of the justices and counsel are going to be attending remotely. I don't think anyone's going to be in the court building, maybe some staff, but no justices and no counsel. And the way it's going to work is that oral argument will happen at 10 a.m. on Monday in this case. At about 9:15, the lawyers are going to get a call from the Supreme Court and be put on a conference call line where they're going to talk to the clerk of the court, who's going to give them a briefing, answer questions they have about procedure and what's going to happen. The advocates in this case are very experienced, and so I don't think they're going to have too many questions. But once that's done, counsel is just going to stay on the line. Their lines will be muted and they'll hang out until 9:50 and then get tossed into the main conference line. And at 10 a.m., the justices will join. The marshal of the court will call the case, and the chief justice will acknowledge the first advocate. And so the way that this will work is that instead of people just asking questions whenever they want, the chief justice will go first, and then in order of seniority, the justices will get to each ask questions. And so there won't be nearly as much talking over each other or interrupting. It'll be kind of interesting just to see, as a matter of advocacy and structure, exactly how this goes. And of course, the junior most justices, by the time they get a chance to talk, time may well have expired already. So it will just depend on how the flow of it goes and how the Chief Justice keeps it moving. I think that it's interesting that this case is a case that's being argued. The court didn't take every case on its calendar and put them all in the May sitting. There were a bunch of cases that were also rescheduled to next term. And by and large, the cases that are being argued this term are things that you would think of as kind of important or things that need to be resolved soon. This case sort of doesn't fit that mold. It's a case that probably could have been decided anytime. And so we were speculating a little bit about why this case is happening when it is. And we wonder if it's just because someone had to go first and they thought they might put a case where the stakes are a little lower on the first day in case there are hiccups to work out with the technical systems or with how it all flows. But that's actually a good segue for me to kick this over to John. John, do you want to tell us a little bit about what's going on in this case, what's going on with trademark law in the Supreme Court generally, and kind of give us the lay of the land here?
Well, thank you, Tejinder. Thanks for that introduction. This case is a trademark case, and I think I should say that at the Supreme Court has a fair docket of intellectual property cases generally, and intellectual property cases tend not to fit the standard lines that everybody is familiar with if you read the front page of the New York Times or any other major paper. you'll see the most important cases, there's oftentimes a 5-4 division, and they're oftentimes along what people think of as traditional political lines. In a case like this, as in other intellectual property cases, they're often, the lines of division are often very hard to predict. And sometimes justices that seem close ideologically are actually quite different on this particular field. And I'm talking more generally about intellectual property because I think that that is the area that we are discussing here. For example, there was a patent case just decided last month, and the lines in that were, it was a 7-2 decision, and the two dissenters were Justice Gorsuch and Justice Sotomayor, who normally you would think of as being sort of polar opposites in terms of the political spectrum, or close to polar opposites, but they joined in a dissent on that case, and the majority, including the rest of the justices. And that's not unusual in this field, that you'll see coalitions that don't look like the coalitions that we normally see in the court. The court has also been rather interested in trademark law in particular. In the last few terms, they've decided 2 cases in which the government lost, cases in which the parts of the trademark were declared unconstitutional. There was a case called Natal versus Tam, which held unconstitutional a provision of the Trademark Act that said you couldn't have a mark that disparaged people or groups of people. And the particular case there involved a trademark, somebody who wanted to trademark the name The Slants for a musical group, and the disparagement was that has sometimes been used as a disparaging term for people of a particular ethnic origin. The group that wanted to do this said, well, we're trying to make fun of that old disparagement. In any case, the government brought that all the way to the Supreme Court. The government had lost in the lower courts, brought it to the Supreme Court, and loses again at the Supreme Court. Then recently, more recently, in the wake of that case, the government also litigated up to the Supreme Court a case involving immoral trademarks. And once again, the Supreme Court said that part of the trademark was unconstitutional under the First Amendment of the Constitution, because the government was not the arbiter, could not be the arbiter of morals in society. So those I think were higher stakes cases, but this is a very important commercial case. In the case here involves a trademark, which is this trademark, Booking.com, which is a hotel booking site. And it says here, it's the world's #1 choice for booking accommodations. I guess that's their motto. This is pulled off their website. And they tried to register that as a trademark with the USPTO. The USPTO at the agency level rejected that on the ground that you can't get a trademark just by having a generic term like booking, which is an English word that people often use to describe making a reservation. You book a reservation, you book a hotel reservation. I'm booking a reservation at a particular hotel. You can't monopolize that word. And even though it's modified here by the .com modifier. So their theory, and the theory that they're carrying to the Supreme Court, is you can't take a generic word and a generic configuration, add them together, and get something that is distinctive and something that is trademarkable in the federal court at the USPTO. You can't register it now. Now you can still have some trademark protections and unfair competition protections. So this is not so much an all or nothing case for Booking.com. Booking.com is still going to exist as a website. It's still going to get a lot of protections from a variety of commercial law. They just won't be able, if they lose this case, they just won't be able to register their trademark. But Booking.com wasn't happy with the government's failure to register, so they took the case to the courts. They sought what's called judicial review, and they went first to the district court in Virginia, and there they won at district court. The district court held that they could trademark this, basically relying on the theory that they had shown through consumer surveys that consumers did not associate booking.com with just a generic term. The consumers knew it referred to a single company and a single product, a single service. Then the government was unhappy with that decision. They appealed to the Fourth Circuit, which is the Court of Appeals here in Virginia, as well as other states. And the government lost again, although they lost with a split panel. In other words, out of the 3 judges on the panel, 2 of the judges ruled against the government, but the government did get a dissent out of the court. Judge Wynn thought the government's argument was correct and that the government should have prevailed in this case, should have been able to deny registration. The 2-judge majority affirmed the district court on a slightly different theory, but did again rely on the consumer evidence, the evidence of survey evidence, which is usually very important in trademark cases. The government then sought en banc review at the Fourth Circuit. That the court en banc decision would be all the judges coming in and looking at the case. The Fourth Circuit denied en banc review, and then the government sought Supreme Court review. Now, when the government seeks Supreme Court review, they often get it. They have something like an 80% rate of getting review granted. And here they had also a very good case for getting the Supreme Court to decide the case, because there was what's called a circuit split. Other circuits had adopted the government's theory and affirmed rejection of relatively generic terms with the .com addition on pretty much the government's theory, not entirely. Some of those courts don't entirely adopt the government's theory. The Supreme Court granted cert, and now we're coming to the oral argument, the merits phase of the oral argument, when the government has to try to persuade the Supreme Court to overturn the Fourth Circuit. Tejinder, I think you were going to start us off with what you think the government's best arguments are.
Yeah, so when you think about oral argument, one thing that's important to recognize for the people in our audience who haven't followed Supreme Court litigation closely is that oral argument is in many ways kind of the end of the road for a case. So as John mentions, the case has gone through multiple rounds of litigation in the lower courts after the USPTO acted, and then this government had to seek review in the Supreme Court, and they file a petition kind of setting forth what their position will be and what the exact legal question they want to review is. Then the parties both filed briefs, and interested third parties called amici also filed briefs. And so you have a ton of paper already before the court. And so as a result, we know pretty much what the parties are going to argue. Oral argument is really going to be a chance for the justices to kick the tires on these arguments, to explore the weaknesses in the arguments that have been made in the brief. It's not a place where we're going to see a significant number of new arguments getting presented unless something is going very, very badly for one side. Here, the government's position is basically that for more than 130 years, there's been this case on the books, this Goodyear rubber case, which says that when you just stick a generic word like wine, cotton, grain, or booking as your name, that's not trademarkable. If it's generic, no one can trademark it. It doesn't matter why, if consumers think it's a brand, consumer sentiment is just irrelevant under this case that's been on the books for a really, really long time. And if you add a generic word to that, like the word company, so grain company, wine company, that doesn't change anything. It's just a generic plus a generic, 0 plus 0 still equals 0. You don't get a trademark. And they say that .com is basically the internet equivalent of the word company. So if booking is generic, which it is, and .com is generic, then again, 0 plus 0 is still 0. You cannot get a protectable trademark in this generic thing. Now, the Supreme Court, it should be noted, it sometimes adheres to its own precedents, but it's not bound by precedent in the same way that lower courts are. It can overrule itself anytime it wants to. And so when you argue to the Supreme Court, you always want to back up any arguments you have about precedent with arguments about policy. Here, the parties have a pretty vigorous debate about whether this 130-year-old case is still good law. And so in order to get the court to decide that it is, the government wants to say, well, actually, you know, the reasons that the court held this 130 years ago are still equally valid today. And their basic argument is that when you have this Trademark policy, generally speaking, is designed to protect intellectual property holders, protect businesses from having other businesses do things that are confusing to customers, right? That is, you want to protect the name of a business so that there won't be knockoffs. You want to protect the investments in goodwill that the business makes. Those things, they say, are not necessary and could be frustrated by extending trademark protection to generic.com businesses. And so an example they give is they say, look, if you have something like booking.com or cars.com or hotels.com, tons of other websites are going to use similar names, right? You might have ebooking.com, you might have eurobookings.com for European hotels, or asiabooking.com. And the concern is that those businesses, which are discrete, which nobody would confuse for booking.com in any event, might be facing trademark litigation from booking.com if that entity is allowed to register its trademark. In other words, the granting of this intellectual property right gives booking.com a weapon that it can wield against all of these other businesses in a way that's ultimately going to be harmful to competition in the marketplace, ultimately not going to serve the interests of trademark law. On the flip side, the government says, you don't really need to protect this mark to protect booking.com, because there is only one booking.com. Only one business can use any given URL. And so there's really not a lot of risk that somebody else is going to come along and say, aha, I am booking.com. That is unlikely, because as long as you type booking.com, you can only ever go to the right business. And so there's no need to extend this sort of trademark protection. And that is basically, in a nutshell, what the government's argument is. There's a back and forth, and they have some responses to the other side's arguments, but I think we ought to hear what those are first and then maybe go back to them. And John, I think you and I have a little bit of a different sense for the relative strength of the parties' arguments. I don't think either of us knows exactly how the case is going to come out, but John, do you want to run us through what booking.com is saying about this whole setup?
Yes, thank you, Tejinder. I hope you can hear me okay. My internet connection just froze slightly. So I think booking.com's argument begins also with this 1888 case on Goodyear rubber, which at the time, it's kind of interesting that Goodyear rubber at the time was itself a generic term. And that, I think, is a little bit of an artifact of history. At the time, Goodyear rubber was, the court had held, meant a particular kind of rubber. It didn't just mean a company, like one Goodyear rubber company, which I think today would be more common. That you'd think, well, Goodyear is just a company. It's not a particular brand, not a particular quality of rubber or thing. But nonetheless, that was viewed as a generic term. And then the question was adding company or incorporated or something else like that onto the end, whether that could make it a generic term, or save it from this generic finding of that Goodyear rubber was generic. The booking.com begins by saying, look, that case was an old case that was decided before the Federal Trademark Act was enacted. And now we have a statute, and the statute codifies a particular test for determining whether something is generic or not. And that's a primary significance test. And that's in section 1064 parentheses 3 of the Lanham Act, which is the Federal Trademark Act. So the respondent starts out by saying, look, you can't just take that old precedent and apply it directly. You have to start with the statute. And I think on this ground, I think the respondents have a pretty good argument, because where you have a case that is a Supreme Court case based on what's called common law or judge-made law, but then the federal government or the Congress codifies a particular statute, there are two warring principles. One, unless Congress says it's trying to overrule the case, if you can read that statute to be consistent with the older case, then you should read it that way. On the other hand, the new test is the test for future situations. So if we had the exact same facts as Goodyear, then I think the government would be right to say this case is controlled by Goodyear, which they say in their briefs over and over again. But the one thing I'm pretty sure of is that an 1888 case can't control the question presented in this case, because the question presented in this case is about internet domain registries, which I'm pretty sure they didn't have in 1888. So what we're talking about in this case is not a direct application of Goodyear, but whether the court should extend the logic of Goodyear into this new area of the internet and internet domain names, where you've got a generic name plus the .com, the sort of top level domain suffix. And there, I think the respondent makes a pretty good point to say, really, if we're going to deal with a new case, then you should look first to the statutory standard and not to the case and try to reason from that first. You should start with the statutory standard and see what direction that statute takes you in. The respondent also makes a number of other points. One thing that the respondent does is it tries to prove that the government is not really being very consistent. And this is something that tripped up the government in the prior two trademark cases that came to the Supreme Court in the last few years, those cases involving disparaging and immoral trademarks. The parties in those cases, the private parties challenging the government, went through the trademark registry and tried to show that the government was being wildly inconsistent, was making judgments that don't make any sense. And the respondent in this case does the exact same thing, has an appendix attached to the end of the brief that has a table of dozens of trademarks that it seems like it's hard to discern how those trademarks are registerable. Government is not one example that they use, and show it is government won a case at the federal circuit in another court of appeals. They won a case denying registration to this for hotel rooms, but hotels.com has a number of other trademark registrations, and the government's theory is very particular here. It's, well, you can't trademark hotels.com for hotel rooms, but you could trademark it for other things as long as it's outside that area of commerce. But you could, for example, trademark hotels.com for an application for a smartphone. Well, it seems a little strange, and it means that, yeah, hotels.com is protected in a variety of things that it does, and that is a problem. So I think there are two major arguments that the respondent has. One is this argument that Goodyear is not really the correct starting place. The statute is the correct starting place, and the statute can be read to be consistent with Goodyear, but it doesn't necessarily control the application to this case. And the other is the consistency argument, which I think is very important. And in that consistency argument, I'll just say one thing about the government's argument is the government's argument does mean that you cannot trademark a generic name that says just co or company off it. This is in the government's brief. You can't do this. This is pet, which is, an animal that you might have in your house, and co. You can't trademark that. But if you do a little surgery on this, if you just delete that period, lowercase the c, and close up the gap there, if you do that, well, then you get Petco, which, as you see, is a registered trademark. This is pulled off their internet site with a little registry down there, and that is trademarkable. Now, I think this is correct. This should be registerable, even though it's just pet and co. It's slightly different, and people don't confuse this. I think if you were to do a consumer survey, you'd find people know that this is a business, and it's a particular business. It's not any pet seller or any company that provides pet products. It's a particular one, and it's slightly different than Goodyear. Of course, it's slightly different, but those slight differences, people, I think, are smart enough to see those smart differences, and I think they can see the difference between booking and booking.com and make that distinction and think one is a company and one is a generic term. So Tejinder, I will turn it back.
We have a question from the chat. That's a kind of interesting question, John, which is if booking.com wins, that they have their trademark should be registered, but they lose their domain name because they miss a payment to their web hosting service. Would anyone who snaps that domain up be infringing the mark? What do you think?
I think that is a great question. I thought about this. I think that they might very well be infringing the mark if they hold themselves out to be booking.com. If they try to confuse consumers about who they're dealing with in this range. Now, first of all, you might think, well, that means that booking.com may just be able to not pay its domain fees. But of course, I think that's wrong, because if they don't pay their domain fees, then that website is going to be shut down. And that would be a catastrophic problem for their business. Even if no one else can pick it up and sort of pretend to be booking.com, still booking.com would be shut down, or all its web activities would be shut down. And that's not something that a business wants to do.
That's an interesting hypothetical, though, right? You know, if there is a disconnect between the owner of the domain, the owner of the mark, it raises like a whole set of interesting questions, which could not really arise probably if you were just trademarking the name of a company, a la the Goodyear situation. I guess you could lose your company name, but the idea of someone swooping in and then registering a new company with the same name would be a little different.
I think we've seen this in phone cases too, right? I think you could trademark a phone number associated with a company. I think that the government does allow that. And if you lose the phone number, obviously that would be catastrophic to your business. But if you're pretending to be somebody else, that's a core problem in trademark law, and it should be a core problem. Companies should not be able to deceive consumers into dealing with somebody who they're not dealing with.
Yeah, so there's another question on chat, which is, do booking.com's lawyers offer any examples of similar companies that have received marks? And the answer is yes. They have tons of examples of companies that have received marks. The brief is actually kind of entertaining to read. There are parts of it where they just go through all the marks that have been allowed and try and ask, like, why is this different from booking.com? And I do expect that an oral argument, that is going to become a major point of contention for the government. As John says, the government's failure to be consistent about what it will register and what it won't register has been an issue in past trademark cases, and I expect the same would be true here. The government's answer is basically like, get over it. The government's answer is along the lines of, look, sometimes we're going to get applications and we're going to register them. That doesn't mean that all those decisions were right. By the way, sometimes we've had to register those marks because courts told us we had to when we didn't want to. And other times, you know, maybe someone got it wrong, but you know, the thing is, unless a trademark registration application is rejected or challenged, there's no mechanism to really review these things. You know, some lawyer who works for the PTO is going to make that call and it's going to stand. And so the government kind of says, you know, don't put too much weight on this question of what we've registered before. You know, listen to what we are telling you now about what the real policy considerations are. And I think a major issue in the case is going to be whether that argument gains any traction.
Yes, and I should say that here is an electronic version of the brief. But this is the appendix, and there are just dozens of examples here. So for example, it begins with art.com, which is an online retail store services for art. And other ones, batteries.com, which is retail services for batteries. Beauty.com, which is, I guess, something, buses.com for busing companies, care.com. And so they go on and on through pages and pages of material that deal with this. Now, the government has a very particular answer also for some of these, which is very technical, but the government defends this in its brief, not just on the grounds that sometimes we're inconsistent, and there's all kinds of reasons for inconsistency, including that we have thousands of employees and it's very hard to make sure everybody's being consistent. But for some, like the example on this page, which is law.com, which doesn't hard to show up there, but if you see that one of the things is law.com, they said, well, law.com does not actually provide legal services, and we didn't register it for legal services. So you can't go to law.com and get help with writing a will. What you can go to law.com for is you can get a newspaper or news about the legal profession. And that's okay, the government says. You can register that because it's not that you're not selling legal services there. And that's also where they have hotels.com did get registered. And again, it can't be for hotel rooms, but it's for all the associated things. So hotels.com does have trademark registry for, and their brief says travel agency services, and there are several others actually, including providing an internet app. Petco, I think, is an interesting example because Petco is registered for pet products, which I think just says that I think the government thinks this doesn't come within the so-called rule of Goodyear, because you've taken out a space and you've taken out a period and squished them together. And that's enough to make that something that could be trademarkable and is outside the generic rule. It seems to me if that's enough, then .com is even easier because there can be only one. And I like this argument. I think this is a central argument that we're going to see in the oral argument. You could call it the Highlander argument, after an old movie in which one of the tag phrases was there could be only one. It was a fantasy movie in which bands of immortals were battling each other, and at the end there could only be one. But there can only be one of booking.com, hotel.com. There can be similar names, and I think the government is right to be a little worried about the possibility of how the registration is going to affect things like ebookings.com or other names that are similar. But that's a problem. That's a standard problem in trademark law. It comes up all the time, and the courts have to deal with that kind of issue in all sorts of different trademarks.
So everybody, I think the next steps for us are to see how all this plays out in front of the Supreme Court itself. The argument, as I said earlier, is going to be at 10 a.m. on Monday morning. And then we're going to be back here, John and I, on Tuesday at noon Eastern to do a debrief where we'll talk about what happened at argument, whether it was consistent with what we predicted here, whether the things that we thought would matter did in fact seem to matter to the justices, and to go over sort of how the new argument format went. In the meantime, here on SCOTUS blog, you're going to see a bunch of content daily just like this. Anyone who's attending here is also going to get a link to the debrief session that we're doing on Tuesday emailed to you. So you can join us for that as well. Thanks everybody so much for coming, and we will see you soon.
Goodbye.